Life Ahead is the name of our show. You're watching PBS Fort Wayne right here. And the reason we call our show Life Ahead is because each Wednesday night we try to give you education and information that will help you with decisions that you have to make in your life ahead. And we're going to do that tonight, this with a legal theme for you. So if you have questions, you'll see the phone number there, 969-2720, multiple times here in the next half hour. And you can give us a call and talk to the attorney right here live on the show and get some complimentary advice. How's that sound? Bryan Nugen.
Sounds great. Thank you. Thank you, Sandy.
Bryan, you've probably seen him if you're a regular watcher of Life Ahead. You've been coming every month for a long time now.
Long time. Yep.
And always with a lot of good information. And I have some kind of different things I want to ask you about tonight.
I'm ready. Thank you.
I know we're going to be talking about estate planning, but some other little things along the way. But let's say that somebody's getting to a point where they think they need to kind of get things in order. Mm-hmm. What maybe you know where it comes from. I was going to Google. I was thinking when you get all your ducks in a row. Mm-hmm. Where did that come from?
That phrase?
Yeah.
I suppose it's a mother duck when she's walking and all the ducks are following behind her in perfect
they
line.
do that when they're swimming also.
They do.
The little ducklings.
Yep, that's exactly right. They bond to their mom and they follow.
Yeah. They don't go much with Dad. You know, he's off exploring. Okay, so to get all of our ducks in a row,
sure.
How many and what documents should you begin to make sure you have legally taken care of?
Right. Well, I don't know that it's a particular number that people are looking for or that an attorney would be recommending for their client. The number of documents, I'm not sure. It really depends person by person what they want to get accomplished. And some basic things that everyone should have in place for sure. We want to have something called a durable power of attorney. And that POA allows someone else to make decisions for you if you're unable to or if you're out of town.
This is like when you're still alive.
When you're still alive,
okay.
But everyone should have a power of attorney. I have a power of attorney.
Okay.
Members of my family have powers of attorney.
Yeah.
Clients have those POAs. Everyone should have one.
Do you have to tell that person they're going to be your power of attorney?
In Indiana, you don't. Yeah, you don't.
Okay.
They don't need to sign that financial power of attorney. They don't need to sign on that. Now, something that is where you do need to put folks on notice in Indiana is if you appoint them as your healthcare surrogate, so someone that would be able to make healthcare decisions on your behalf, you are required to provide to them a copy of that healthcare representative designation. That's a second document that you might want to have.
And you have to provide that to that person?
You do. You're responsible to provide it to the person. So typically an attorney's office may mail that out or send it to the individual that's been appointed.
Do they have to have it in writing or can you just verbally tell them?
No, it should be in writing. They should have a copy of that designation.
I have some work to do.
Well, that wasn't always the case in Indiana. I'm not sure. Maybe that's been in effect for 3 years now. Could be a little bit longer, where you have to provide that surrogate, a copy of that healthcare representative designation. I think it's also a nice idea, although that typically within that healthcare surrogate designation, that healthcare representative designation, we've included HIPAA language. HIPAA, Health Insurance Portability and Accountability Act. That language is typically within that healthcare surrogate designation, but I'd like to see a separate HIPAA authorization in place. I think hospitals are used to seeing those, doctors are used to seeing those, and sometimes it's easier just to provide that form individually.
We have to sign, like if you go to the hospital, even just for a procedure and you're going to be there for an hour. I mean, you're signing about 5 or 6 different things.
Well, one of those things that you're signing is a HIPAA authorization.
Right.
So for that
Say again what HIPAA means. I always intend to look it up, but I haven't done that.
Health Insurance Portability and Accountability Act.
Okay.
And it's allowing the individual that you're working with to see your medical records. So for the example, Sandy, you were giving about being at the doctor's office or the hospital, you're allowing the doctor's office, the hospital, to reach out to your insurance company for them to be paid for the services that they're performing. So they can't just contact the insurance company unless you say it's okay. So that release that you're signing each time that you go is specific to that event. What I'm suggesting is you have a HIPAA authorization that's in effect, that's much more general, much more broad, that's in effect indefinitely, and those individuals that you appoint in that document would be able to see your medical records, speak to the doctor about your medical records, et cetera.
Do you get that at the hospital or from the attorney?
Well, It could be either. I can't speak for what instruments that the hospitals have or the doctor's offices have. I can tell you that lawyers do have those and would regularly prepare those for their clients. And it could very well be that hospitals have forms as well. I would guess that the hospital ones are related to that event that you're attending the hospital for,
yes,
and maybe not broad.
But it seems like about the same ones every time you go, so I don't know. But it's, I know there's, like what you're talking about, and then it seems like you sign something to say that the hospital can release your information to, and then you can put a name or whatever of whom you're okay with them knowing the information.
Yes. So the hospital may very well have a form that you would complete that would indicate who can speak to the doctor while you're there, who the hospital can speak with. That wouldn't surprise me at all.
Yeah.
You were asking earlier about what other things that folks may want to have in place. I would think last will and testament is something that's very important for folks to take a look at and for them to make a decision about where their assets go when they pass away, who's going to be in charge, making sure that that individual knows to satisfy your debts, etc. And sometimes we also want to use trusts as part of our estate planning. Not always, but oftentimes those are instruments that are appropriate to have in place. We use those trusts. Normally, there are three categories of folks involved in those. First is the settlor, the grantor, the trust maker, the person that made the trust.
Say that first word again.
Grantor. So grantor, settlor, trust maker, they're all the same.
See, I learn a new word every time you come. Yep.
Well, so that would be you. If you were putting together your estate planning and you were the one that was putting that trust together, you're typically the one that makes it.
I'm the grantor.
You're the grantor, settlor. You put that together. The next position in trusts would be someone called a trustee. If we have a type of a trust called a living trust or a revocable trust, normally the person that creates those trusts is their own trustee, their own manager of the assets that are in that trust. They make distributions to a third group of persons called a beneficiary or beneficiaries. That's who can enjoy the money that's in the trust. In this instance, if it's a living trust, revocable trust, you would be your own beneficiary during your lifetime. You would be able to enjoy the assets in it. And so as part of your estate planning, you're indicating after I pass, where does that money go? And we normally would indicate within our trusts or our wills who it is that ultimately receives those funds. It could be children, partners, spouses, charities, PBS. Right? We can remember PBS. I've had more than one client that's remembered PBS.
Good.
Yeah.
That's great.
In any of those estate planning, the individual would be looking at, should I have a will? Do I need a trust? What's appropriate for me? What's not appropriate for me? And also, we're wanting to make a review of the assets that we have, investments that we have. Can we put designations of beneficiaries on those assets? Maybe it goes directly to a person. Perhaps it comes into the trust. Perhaps it comes through your estate. It depends. It's unique for each asset that you have and what you want to get accomplished.
And I know you can put more than one person.
Oh, yes.
I've done that.
Yeah. You can put 1, 2, 10, however many you want. You better believe it.
I just have 2 kids. I don't have 10. So, unless unless somebody out there is interested to join the family.
They want to step up.
Okay, so now here's what I do know, because you've talked about this before.
Sure.
If you put in your will, for example, that you want to leave your IRA to your cousin, but you have signed the beneficiary for your child. The beneficiary is the one that wins, even though
That's right.
it's different. The beneficiary that you've signed takes precedence over your will, and that surprised me.
Yeah, so it's important when you have your estate planning done. You take a good hard look at the beneficiaries that you've designated on assets like your IRA that you're referring to, Sandy, and make sure if your estate planning that you did through your will or your trust is different than your beneficiary designation on that asset, that we have designated the will, we've designated the trust, your estate rather, or your trust as the beneficiary, if you want to do something different than that. So look at it very closely. Once you create your will, once you create your trust, you want to do a thorough review of the investments that you have. You want to do a thorough review of the beneficiaries that you've put in place. If you're using a trust, normally we transfer ownership of those investments, those assets, to the trust itself. And so you bring up an excellent point, which is to be very cautious about how those assets are owned, how they're titled, and
you may
the
forget,
beneficiaries.
I mean, if you do your will and 10 years later you have some kind of investment and you
Very
sign up
possible.
a beneficiary that maybe wasn't even part of your family at that time.
Well, this is a surprise for folks. We'll have an estate and everything goes through smoothly, and all of a sudden we find an asset, and perhaps that the asset wasn't put into the name of the trust if the client had a trust, or a beneficiary, to your point, a beneficiary is designated that the individual wasn't thinking they were going to remember, or maybe they weren't going to remember that much. Oftentimes, too, when folks are designating beneficiaries, they're thinking about the value of that individual asset. And that asset may go up or down in value from the time that you designate a beneficiary. So I like to use percentages in estate planning. I think that makes sense. So if your estate expands, we know that we're giving someone a particular percentage of our estate. And if it shrinks, they're receiving a particular percentage. So if you're concretely thinking, this asset goes to one individual, this asset goes to another individual, that works great if nothing changes in your life. But if this asset increases in value and this one goes down, you're now treating them differently than you thought.
That's why a percentage is good, because that's going to remain equal. We have a phone call that Brian's going to answer here, I'm sure. Jerry, that's you. You're on the line here with us tonight on Life Ahead. What's your question for Bryan Nugen?
Yeah, Brian, my question is, at what age should one start considering doing estate planning?
Good question.
It's a great question. I will tell you, estate planning is appropriate at any age.
Okay.
So I'm an elder law attorney. Elder law does not mean that
you have
elder
to
law
be
attorneys
elderly.
are only working with folks that are traditionally elderly. If you're at 18 and you have assets, of course you should consider all these things. I encourage folks, actually, when their kids go off to college, get a durable power of attorney in place, get a healthcare representative designation in place. You think because they are your child, you can make decisions for them. You can talk to the doctor. You can't. All right? We may need to have a guardianship. So those very basic things should be in place when you're young and going off to school or graduating from high school, whether you do or don't go off to school. So as far as estate planning, I think typically folks are looking at estate planning at several stages of life. So to answer your question, Jerry, I see folks that are doing estate planning oftentimes when they have their newborn, first child. They may not have garnered a lot of wealth yet, but they have this precious baby. They want to make sure that the right person is taking care of that child, and if there are assets, who it is that's going to be managing those assets for the child. So there is no particular age. I see life events that trigger folks doing estate planning, first child, an unexpected illness, and all of a sudden we realize, oh my gosh, we don't have anything in place. Maybe a first trip for the family where they're flying and people are nervous. We don't have anything in a place, and we're flying. My gosh, the plane could go down, and so we better put some things in place. When we're thinking about retirement, when we're getting ready for retirement, when we've just retired, I see estate planning a lot of times taking place then. And as we age, when we start to have a concern about, my gosh, if I need care, how am I going to pay for that care? I've worked my whole life to produce these assets. I want to make sure that those assets are with me my entire life. I don't run out of money. So how is it that I can plan to protect those assets and secure benefits to provide payment for my care as I age? So great question, Jerry. I really do appreciate your calling in. But there isn't a particular age at which someone should do estate planning. When you're 18 and above, it's something to consider.
Jerry could make that call tomorrow, and have everything solved before New Year's.
Yeah.
How often should somebody review their estate planning, though?
Great. I like to see people every 5 to 7 years take a look at it. And when we do those reviews, folks are often at times surprised. Oh my gosh, I don't remember we appointed this person, or I made this really complicated and it isn't that complicated anymore.
Yeah.
Or people have come in and out of your life, things have changed. So I recommend every 5 to 7 years, take a look at it, make sure things are in place, laws change.
And families change. I mean, it seems like nowadays there are a lot of blended families, and that complicates things if you don't have everything in writing.
Yep. Without it in writing, then there's something called intestate succession.
Intestate succession.
So last will and testament, intestate. I died without a will.
Okay.
And then the state doesn't necessarily get the money, but the state would determine where the money goes.
If you don't have a plan.
If you don't have a plan in place, you haven't put the beneficiaries in place, you don't have a will, you don't have a trust, then we use something called intestate succession. It's especially important for spouses, first spouse, second spouse. Folks think that because you're married to someone, you automatically receive all of the assets, and that is not the case.
I know, that's like the commom thing people think.
Yeah,
I mean,
know.
was it ever that way that they started
not
believing
since I've been
that?
practicing law. No, spouses are entitled to some of the estate. Kids are entitled to some of the estate. So you're going to want to make sure that you've put it into effect as you want it to be in effect.
Okay, and then the state also in this list of how things are going to be, what do you call that list? What do you call that list?
Intestate succession, how it's divided,
Yeah.
percentages based upon your relationship
And
to the
that's
decedent.
the same all over Indiana.
It is.
Now, this leads me to another thing I want to talk to you about. I know you're also certified in Michigan and Florida.
I am.
Okay.
I'm licensed.
Congratulations to that.
Thank you. Thank you.
So, say somebody is wintering in Florida, which a lot of you do around here. I know this is a kind of an area of snowbirds, meaning as soon as we've had the first big snow, which we've already had, and it starts turning colder, we start heading to Florida or the Carolinas or someplace to stay warm for the winter. So if somebody had worked with you in Fort Wayne, say, then if they go to Florida, you can still counsel them and know the Florida law. Is that it?
So me personally, yes, I'm licensed in both states.
Okay.
But what I would say that's important for the audience to take is that if you are traveling between states, normally there's reciprocity between the states, meaning if I have Indiana documents that I've prepared and they're effective in Indiana, and I go to Florida and I need to use that power of attorney, that healthcare rep designation, living will, something like that, it's recognized in that state as well. There's reciprocity between the two states.
So one state law or whatever may not be the same for every state in the United States.
No.
Each state can make up
It's a
their
little
own
different.
rules.
That's right. It's a little different.
Okay, all right, there you go. All right, so now the other thing that I want to talk about is like snowbirds going to Florida. Are there things that people should take care of if they're going to be gone for like 2 or 3 months or even just a month?
Just on a personal level?
Yeah.
Well, I think that stopping the mail is important.
Yeah.
Making sure that your heat is appropriate, turned on. I think even the remotely controlled thermostats are great. If you're able to, fortunate enough to be able to put those into your home, you can look on your phone and make sure you haven't lost heat and don't come
Water
back to
heater?
broken pipes.
I always turn that back.
Do you?
Yeah. Huh. Okay.
Clean your refrigerator. We don't want any food in there if you're going to be gone.
Oh, good. Yeah, that's a good point.
Yep.
That's a good point because, like, who knows? Electricity. And that happened actually to my daughter a year or so ago. They were gone for like a week or 10 days or something like that. And that's when we had a major storm here in the Fort Wayne area, and trees were down everywhere. I mean, it was just a bad thing. And many sections of Fort Wayne were out of power for a couple of days. Well, they had also lined up somebody to come in and paint while they were going to be gone. You know, they lined up a painter to paint all the rooms in the house and whatever. And so they had me go over and check and make sure he got in and had everything he needed. And what did I see but a big pool of water all over the kitchen floor where the refrigerator without power.
Yeah, that's not good to come home to.
No, it wasn't. But thank goodness I was there to mop it all up and before there
lucky to
was
have
any
you.
damage. But what, what if they didn't get back home for another 5 or 6 days?
Sure. Well, they were lucky to have you to check in on the house.
Oh, thank
for
you.
sure.
You complimented me plenty tonight
true.
here. So legally then, you would recommend that if they're going to be gone for a long time, to have things like your power of attorney,
Yeah. So-
healthcare rep, those would all transfer?
They do transfer regardless of what state you're in. But I think what you might consider doing as well is making sure that those are available to you digitally. So we're in a very digital world now. So what you may consider doing is downloading those documents so you have access to them on your smartphone or on your computer, so that if you happen to be, to your point, Sandy, in Florida and you needed those documents, that you would be able to access them online and have them available to you.
Okay.
You may also consider back home before you leave, whatever physicians group that you're affiliated with or hospital that you're affiliated with, to make sure that your physicians group has a copy of those documents related to your health care.
Good point.
And you may also consider your durable power of attorney, giving that to your financial advisor so that your financial advisor and their team have approved that it could be used, making sure that your banks have those POAs so that if a check needs to be signed, it's already gone through the bank's legal department, they've approved it, they've accepted it. And so if somebody needs to act on your behalf, it's already gone through that
Now,
process
do you have
of
to
approval.
have, if this is like, as you're aging, but you haven't passed yet.
Yep.
And you've named a power of attorney who can pay your bills while you're gone all winter.
True.
Does that person need to go to the bank and sign anything, or how do you
No.
let the bank know
So-
that's okay with me?
So the point of delivering the power of attorney to the bank in advance of needing it is that normally they need to be approved by the legal department. If it's the bank or
Oh,
if
I
it's
see.
your financial advisor, your investment group, whoever you're with,
Yeah.
they typically send it to their legal department. They approve it so that if the situation arises, you do need to sign a check, then you would be able to sign the check. You aren't going to, the attorney in fact, that's the person that's serving under that POA, that power of attorney, the attorney, in fact, isn't necessarily going to the bank and signing a signature card or anything like that. We would do that in an instance where you're appointing someone that could sign on your account, right? They're an authorized signer. And that event, which is different than using a power of attorney, you would go to the bank in advance and have the individual sign and make sure that that signature is on file.
Okay.
Yep.
All right. Got it. Okay. Now, what if somebody passes away, Brian, and they don't have a will? Shame on them. If they've heard this show, they know that they need to. But
Yeah.
but I don't know. People always think I'll do it next week or do it next year. What if you pass away and you don't have a will?
So that's what I was referencing earlier. If you pass without a will, then the state of Indiana, assuming we've passed in the state of Indiana, has a whole schedule that they use to apply where assets are distributed. I will point out, if folks are wintering in Florida and they have real estate or assets in Florida, they have real estate and assets in Indiana at the same time, you have to open two different estates. So you have to open one in
really?
Florida, you'd have to open one in Indiana. So I would strongly encourage folks, if they do have assets in different states, to use a trust to put those in so we don't have to go through probate in both states, or use something like a transfer on death deed in Indiana, ladybird deed in Florida, beneficiary designation, something so we don't have to go through probate in both states. But typically, I'd like to see a control of how those assets are distributed, normally by using a trust or perhaps a last will and testament.
Okay. Now, what does what can somebody do to eliminate or prevent issues with the estate for their heirs in terms to minimizing any problem?
Well, number one, I think when someone passes, it is an emotional time. And I think the less stress that you can have your heirs, the folks that are responsible for you at the time of your passing experience, what a kind thing it is for you to do for them. It is very stressful. It's not, it's a difficult time. And all of a sudden, mom passed last week, and now all of a sudden, and we're grieving, and now we're dealing with money and how that's distributed, and people are asking questions, et cetera. So I think as an individual that's preparing their estate planning, reducing the accounts that you have. So if you've got 5 or 6 different accounts at different banks, maybe bringing those down to 1 or 2 accounts. If you have investments spread in different areas, organize those investments. Take a good thorough look at your assets. Are they in a trust? Do you have beneficiaries designated? Do you have those things organized? So I think that's a huge benefit or nice thing that you can do for loved ones, for people around you. We were joking earlier about making a gift to PBS. If you want PBS to receive something, to make sure that you've indicated that PBS is receiving something. By your telling friends and family, by your telling your spouse that you want to have this happen or that happen, it doesn't automatically happen. If you want someone to receive this sofa that I'm sitting on, it's a sentimental sofa, and we want to make sure Grandma's sofa goes to somebody, you need to put that in writing. So sometimes things are distributed in a way that were unintended or that we didn't want without some advanced planning. So I would encourage folks to do that advanced planning.
All right, we'll make a deal. You can have the sofa.
All right.
I want the coffee table.
It's
this
yours.
is a pretty cool coffee table. Good advice, Bryan. Thank you so much. Jerry, don't forget all the things that Bryan told you and take care of things. And thank you for watching Life Ahead. Well, for the rest of you, we're not done yet. We're going to have a Life Ahead show every Wednesday night here at 7:30 coming from the PBS studios. Have a great weekend, and we'll see you later.
The preceding program on PBS Fort Wayne was made possible in part by
Nugen Law, focusing on estate planning and elder care law, emphasizing independence and quality of life. Serving Indiana, Ohio, Michigan, and Florida. More information at nugenlaw.com.